Welcome back. Our panel now has Judge Hand on my right.
Okay, I think we're missing one of the people.
Oh. My panel now is Judge Hand on my right and Judge Brennan on my left. The next case this morning is 2024 P386 Commonwealth versus Escalante.
Excuse me.
Good morning. Good morning, Your Honors. Attorney Dave Rotundo for Ms. Escalante. In this case, the judge found, after a hearing on the motion to suppress, that the defendant was pulled over for a traffic violation without incident. I believe he did not have his lights on. The trooper requested his license and registration without incident, and at that point, the defendant produced a facially valid New Hampshire license and registration. Now, I believe that you've all had a chance to review the video.
We have, so could I just pause you on that, because there seemed to be something was expired.
Yes.
And so then, what was that? Was
I
that
believe it was insurance. The insurance, she said your insurance was, it's expired, and he, at that point, began to look to see if he had an updated insurance card. So that was kind of the time period that there was some open-ended questions unrelated to the traffic stop. So I believe on the video it goes about 7 minutes until we get to the question, you know, what do you have in the bag?
Counsel, can I ask you a question? Are you taking the position, are you taking the position that the trooper did not have the right, once she received the facially valid license and registration, to go back to the cruiser and verify?
Well, I mean, I believe in all cases there needs to be a verification. Okay. However, I believe that once she received the license and registration, at that point, you know, that does not create an open-ended window for unrelated questioning. So,
does the New Hampshire license then raise, because as we know, you're not required to have insurance in New Hampshire, which, again, if it's a Massachusetts registration, I think you take them, you walk back to the cruiser, but doesn't the New Hampshire registration at least raise the question of valid insurance?
I can't answer that question with regards to New Hampshire. But in this case, I think we have to look at the environment he was in. This isn't a case where, you know, we have 7 minutes of questioning by the officer, and she was very polite, I'll give her that, but she kept asking questions related to, you know, what's in the bag, where are you coming from, why would you be an Uber driver in Massachusetts when you're from New Hampshire? So it kind of, the questioning kind of just escalated. Now, he wasn't free to leave. He was confronted by an armed police officer, and he was not informed that he had a right to refuse consent to search the bag. Now, on the Commonwealth relies in their brief
to break it down, though, a little bit. So he's looking for this insurance paper, whatever it is that she wanted. Is she permitted at that point to be asking him questions? And I will say she really did have a lovely tone, and was asking him questions about where he was from and whether he liked that model of car. Was she allowed to ask him those questions?
Yes, I think general questions, but when you start to get into, you know, questions unrelated, you know, to the routine stop or routine questions like you had just mentioned, you know, where you're coming from, that kind of thing, I think, you know, you get into, it's a slippery slope at that point. And
so on that issue, there are plenty of cases that talk about the temporal scope of a stop and when the stop theoretically should end. Are you aware of any cases that discuss subject matter scope? To be clearer, for example, here, your client didn't have his headlights on, and there's all sorts of chatter about all sorts of other things that, to my eyes, look like Trooper Training 101, where you got an opportunity, let's try and see what you can figure out and find out, and while you're chatting them up, if you happen to get a little something, go with it.
Well,
should there be a limit on the subject matter of conversation if there isn't already?
Well, I'm not aware if there is a limit on that, but
I couldn't find any cases that said it. But so the question is, I guess I'm asking you now is, do you think there should be, just as there's a time limit, should there be, depending on the nature of the stop, a limit on the types of subjects?
I would say yes. I would say yes. I think questions that are investigatory in nature, like, specifically the question in this case with regards to what's in the bag,
I mean, theoretically, where you're coming from, how long you've been in the country, where's your Uber identification sticker on your car. There's all sorts of questions that are in and out there.
arguably, I mean, that may be on the scope of questioning as well. Once he produces a facially valid license and registration, which he did, I realized that, there was an issue with regards to the insurance. However, at that point, I believe the officers should have took the license and registration gone back to the cruiser and done some type of confirmation. Now, the Commonwealth argues in their brief that they rely on distracted glances at the bag to create a reasonable suspicion of criminal activity. And, from my view of the video, I didn't see that. There was no evidence that the defendant displayed any nervous behavior, evasive behavior, or other indication of any type of criminal intent. So, the case law currently, the way I read it, it would be that this delay was too long, and once she received the license and registration, she should have went back to the cruiser and verified and confirmed the registration. Then he would have been free to leave.
Am I understanding that you're making an argument that there was clear error in the judge's finding that the defendant did make those, was sort of looking over at the bag in a way that drew the trooper's attention?
Well, I reviewed the video and I didn't see it, so I would say that there was error there.
The video, would you agree with me that the video camera is at different times, at different heights according to where the car is? Sometimes you're looking at the side of the car door, and other times at a reflection in the window of the trooper, just based on the way that the position of the camera was. Do you agree with me about that?
Right.
So, in fairness, would it be correct to say that the body cam didn't capture every moment, excuse me, of the interaction that took place there, at least in a visual way?
That is correct. That is correct. But I think I think with the body cam evidence, I think there's even a stronger argument that this stop was this confirmation was unduly delayed. 7 minutes just seems unreasonable.
Is it your position that the 7 minutes, the delay was caused by the trooper, or was the delay just existed because of what the trooper was asking the defendant to produce?
Yeah, I think that he said he was looking for insurance, but and I would say that the trooper probably at that point had an obligation to, when he couldn't find it, just to say, okay, I'm going to go run your license and registration. And I think, and I can't speak to New Hampshire law, but I can't think of any reason why they could not validate a New Hampshire license and registration via their computer.
But does the fact that, let's assume for the moment that he was glancing at the bags because the video doesn't show everything that she saw, and he says he's driving for Uber in Taunton, but he lives in New Hampshire, does that combination give the officer any reasonable suspicion that criminal activity is afoot?
I would think not. I mean, I don't see how that points to criminal activity. I mean, it just that, maybe he's nervous, maybe
Oh, he was remarkably not nervous, actually.
Right. Well, why he said that, I mean, I don't know what the competition for Uber fares are, but, Massachusetts is, border with New Hampshire, so I think it's reasonable. I don't think that should that should raise a flag as to criminal activity, no.
So the trooper testified at one point that the defendant was glaring at the bag, but the judge only found the trooper noticed the defendant looking at the backpack. So I'm trying to, in my mind, figure out what notice the defendant looking at the backpack permits a police officer to do. Is that a reasonable suspicion?
I don't think
see any
that's a
testimony
reasonable
whatsoever
suspicion.
in terms of safety concerns, so, go ahead.
Well, if it was a safety concern, she would have pulled him out of the vehicle.
It wasn't articulated in any event, so let's just stick with reasonable suspicion. Does looking at a backpack give a reasonable suspicion?
I don't believe it does. I don't think it's suspicion of
Have to
anything.
characterize it? Sorry to interrupt you. Go ahead.
I don't think it's suspicion of anything. I know, I've been pulled over for traffic violations, and, and even being an attorney, you get very nervous, and, who knows why he was looking at his backpack, but he glanced at it. I don't think the video supports that he was, staring at it or made a move towards it to hide it or any of those type of any of that type of display. So I think that I don't think that there's a reasonable suspicion of any type of criminal activity in this case.
So there is a factual finding that I don't think you've challenged, that the defendant was in fact relaxed and engaged in polite conversation with the trooper and did not appear nervous when he volunteered that she could search the bag. So how does that impact our analysis?
Well, I think that his consent is arguably ambiguous, right? She said, can I search the bag? And he says, well, she asks, do you have anything in the bag? And he says, why? You can search it, why? He asks the question, why do you want to search it? And then she, directs him to open it for her.
But are those mutually exclusive? You can search it, but why?
Well, I think the consent was in a coercive environment. I think it wasn't a true voluntary consent, and it was only an acquiescence to the authority of the police officers.
So the Commonwealth cites Commonwealth versus Ortiz, a SJC case from 2018, and I'm quoting, to establish that consent to a search is valid, the Commonwealth need not prove the consenting person knew they had a right to refuse consent or that they were informed of that right. What's your response to that?
Well, I would distinguish between a situation where it's a motor vehicle search and a search with someone who's not in a motor vehicle, like a pedestrian. I think, in the motor vehicle situation, it's more of a coercive environment, and I would almost argue that, it should be informed of the right, that has a right not to consent, because the person, individual is not free to leave in that situation. I don't have anything else.
I was just going to ask you if you happen to have brought a copy of Commonwealth versus Brown with you, because you cited on page 18 of your case, but I couldn't figure out exactly what language you were relying on. If you don't have it with you, then we'll muddle through, but if you happen to have it, I would ask you. You say the fact that his response to the request for information as to the contents of the bag, you can check why, does not obviate the need to determine voluntariness, and you cite Brown. And I just wasn't sure what you were relying on there.
I don't have that case, Your Honor.
That's fine. We'll figure it out.
Okay, thank you.
Thank you very much. We understand your argument, and we will hear from the Commonwealth.
Yes, good morning, Your Honors. May it please the Court, my name is Rob Kidd, Bristol County DA's office. First, I just wanted to correct a misstatement my brother made, and I know it was not intentional, but the Commonwealth, just to be clear, we are not arguing that there was independent reasonable suspicion for the judge, for the trooper to search this bag in the seat, although that may be the case. The argument that I make in my brief is that there was consent. And in determining that the consent, here's what happens. We know the sequence. If you watch the videotape, about 6 minutes into the encounter, after the officer is asking some questions, the defendant is trying to locate the correct documents. The officer is asking valid questions about where he has come from, where he is going to. Those questions have been sanctioned in the case law. Why do you have this Uber from coming all the way down from New Hampshire to Taunton, which is probably 70 miles?
What case sanctions those? Because there's definitely case law that says they can't go into a general investigatory mode. They have
Correct.
to, like, how does where did you come from, where are you going have to do with him having his lights off?
Correct. And so if you look at Commonwealth versus Torres, which is the first in the line of cases, and it's the one that's commonly cited by defense counsel, sort of the first case where we have this rule that, probably not the first, but the first big case where there's this rule that you have to disengage with a motorist after you have, determined the violation and written the citation. In that, the court specifically found that the first part of the interaction of the officer with the defendant, in which the officer approached the car with the two men, talked to the defendant, asked the defendant where he had been coming from, where he was going to. It was that the car was not registered to the defendant, it was registered to someone else. The officer said, well, who is that? And so on and so forth. That was fine. Where things went astray in the Torres case is that the passenger, which was Mr. Torres, had left the car, and the officer had asked Mr. Torres to stand at the back of the car while he questioned the driver and got the documents from the driver. And what went astray in Torres is after the officer got the documents from the driver, he goes over to Torres, who's standing outside the car, and proceeds to interrogate Torres and say, he asked, can I see your wallet? And Torres pulls out his wallet, he looks in the wallet, and he sees what he thinks is a drug ledger and some other things, and now obviously he's getting suspicious, and then he sees the driver moving, and now he's suspicious of the driver. He goes back to the driver, he pats down the driver because there's a bulge in his pants, and it turns out to be a pager. So all that stuff that I just talked about happened after the production of the valid documents. I'm sorry.
So I don't know the date of Torres, but Commonwealth versus Bartlett, which is from this court in 1996, says, and I'm quoting here, questions about where the defendant was coming from and where he was going were held to constitute investigatory conversation for which the officer had no lawful basis once he had received a valid license and registration.
Correct. I'm not going to tell the court that these cases don't oftentimes have different say different things for similar fact patterns, but you really have to, and I've said this before, unfortunately, these cases oftentimes confuse me because you really need to look at the individual fact pattern of each and every case.
So getting
I
back
would need
to
to know
this,
what the context of that was said. I'm sorry, I interrupted you, Honor. Go ahead.
No, so let's get back to this fact pattern, because in looking at the video, he is having trouble finding some document, but it does seem like, and I'd like your take on this, it seems like she has what she needs to go run his license and registration at the moment she says, do you have anything good in the bag? So it seems like right at that moment, she could be going and running his license and registration, but instead of doing that, she asks, do you have anything good? Do you agree with that?
I would agree with that, yes.
You agree with that, okay.
Yes. That's about 6 minutes, 6.5 minutes into the interaction with him, yes. So with that, as the court knows, there's a line of cases that tells us that the officer doesn't need to ignore what she sees and hears.
All right, so,
the interaction.
yeah. So you anticipated my question, and you argue in your brief that the officer is not required to ignore incriminating facts that arise during the stop. The question to me is, can or should an officer seek to create incriminating facts during the course of the stop? And we'll start whether theoretically that is a principle that we agree with, and then whether it happened here.
to give a lawyerly question to a question. I don't know that I understand the question.
Yeah. So do you think there's a difference between, I mean, you can look and see what's happening, or you can go into it with, you know, I'll give you an example, won't name the person, but there was a police officer in a different department who every stop would say, hey, any drugs or guns in the car? Most of the time, I think it was probably a no, but every now and then you got a hit. Is that okay? Or in this case, chatting the guy up while he's looking for his stuff, clearly looking for a gotcha moment, since literally the trooper at 8:20 says, gotcha, gotcha to herself after she sees the bottles. I mean, what she's doing is clear to me, is looking kind of for a gotcha moment and trying to find ways to pleasantly engage in a way that might create some opportunity to find criminal conduct.
I think we just need to look at the nature of the questioning, the specific questioning, to answer your question. I mean, yes, I'm curious as to what happened to that officer who asked those questions at every stop. But anyway, that's another question. But yeah, I mean, I don't think that's not tied. You know, that's not tied to the reason for the stop. I think where you're coming to, where you're going to, those are reasonable questions. And why are you down here in Taunton on an Uber? You know, from 70 miles away, what are you doing down here? And I think the defendant did a pretty decent job of answering those questions, but those are natural questions that the officer had, and I don't think they're impermissible.
So the judge found that the trooper noticed the defendant looking at the backpack, and I think that's all we have, because as Justice Hand pointed out, right, a lot of it, I'd say more than half of the time in that first 7 minutes, we're looking at the side of the car, and so who knows which way he's looking. Okay. Is that enough under those circumstances to permit the trooper to say, hey, anything good in the bag? Or is that the type of kind of investigatory question that, in conjunction with the guy just having his headlights off, isn't proper?
Correct. First, I would respectfully disagree with your take on the judge's findings. Remember, the officer testified, she used the word glaring, and I would suggest just because the judge did not use the word glaring in her findings doesn't mean that she is discrediting that testimony. I would suggest that if the judge were going to discredit the officer's testimony, she would have said so. And there's nothing in the judge's findings that I could see that discredits any of the officer's testimony. So I would say the word is glaring, and glaring implies that the defendant was doing more than looking at the bag. His eyes were fixed on it for some period of time during the interaction. And I know it's not visible during the camera, with the camera, because
and it just seems a little counter to at least my read of him, which was utterly oblivious to the fact that having all sorts of meds that may or may not belong to you in a bag is a bad thing. I mean,
well, maybe, but I mean, just
but the finding is the finding.
Right.
So
and on a pure physical level, I think it's difficult for a camera to pick up eyes doing this.
Right.
You know, I mean, I think there's the officers a few feet away, and I think that's why we have to give deference to the officer's testimony.
But that's, I mean, on a pure physical level, I'm trying to understand how somebody in the driver's seat who is looking across the passenger seat at a trooper doesn't ever look at the bag. Because you'd have to maintain eye contact with the officer the entire time, which is not normal human behavior. In fact, that might get you spread on the hood of your car.
No,
so you're going to glance down, and you could go look at any court hearing where I've been on the panel, and I'm a person who glances down. So that doesn't, I'm not really looking at my calendar in front of that they've got here in front of me. I'm just looking down, thinking, right? So how does he not look at the bag? I don't even understand that.
I think he could look at the bag. He could look at a lot of places. He could look around. He could look in the glove box. But if the officer, I'm not being overly deferential, but if the trooper said he was glaring, it means that she is describing someone whose eyes keep going back to that particular location in the car, not the glove compartment, not her, and that's a subtle observation that someone would see, and that would be my answer to your Honor. But the interaction here, so the consent is based on, the officer asked that one question
Right, but
after she...
that's the question. Why, when she's holding his documents and she could walk back to her car and check them, why at that moment in time is she permitted to say, do you have anything good in the bag?
And that's a question I anticipated. But let's take it further. I would suggest to you respectfully, it would be bad police work if we credit the officer's testimony in the body cam footage that she's got this guy coming down from 70 miles away driving Uber who keeps glaring at this bag.
Let me just clarify, the judge didn't find glaring. The judge found looking.
No, I understand that. I understand that. But anyway, we have this defendant apparently preoccupied looking at this bag, according to the judge.
So again, and I don't mean to interrupt, but it seems to me that that is the crucial point, and I'm not criticizing the judge and the judge's findings, but the judge doesn't characterize it as staring, glaring, focused, repeated. It just says, saw the defendant looking at the bag, which seems, one could say, okay, so if you take that, and that's the finding of fact that seems to me we're all, stuck is not the right word, but that we all have to work with.
Well, again, I don't want to belabor the point. I disagree respectfully, but let's go with, this is where the court's going. Even if he was looking at the bag, the finding was that he was preoccupied, or I think that was the word, during the interaction. It would be bad police work, I would suggest, if the officer were not, the trooper were not to ask that one simple question before she went back to the cruiser and before she ran the information.
So can I, good in the bag? Again, I don't want to be arguing back and forth, but the word preoccupied would have been helpful. If you were preoccupied with the bag, then I'm there, and I'm not saying I'm not there anyway.
Distracted. I think that distracted was the word.
She said the finding was the trooper noticed the defendant looking at the backpack. She drops a footnote and uses the word looking again, and it's based on 2 lines of the trooper's testimony, which are based on him glaring at it. I asked him what was in it. Actually, at the time he was speaking to me, he was distracted by a backpack that was seated on the front passenger seat. So trooper says distracted and glaring. The judge finds the trooper noticed him looking at the backpack.
I understand. Again, I would suggest in the circumstances, in the totality of the circumstances, what she has with this driver, where he's coming from, and the fact that he's looking at this backpack, I think she can certainly ask the question. It's not a crime for the police officer to ask a question. It's not.
But to Justice Henry's question, that I think is the crucial. If what we have is the trooper has the license, the registration, and the insurance information, okay, and at that moment, rather than going back to the cruiser to confirm, based solely on seeing a person look at a bag, can they take that extra 3 seconds to say, hey, is there anything good in that bag? Or does that go beyond?
In this particular case, I think she could take that extra 1 second to ask that question. Is the court going to make a rule here today, with all due respect, that 1 second was an unreasonable detention of the defendant after she had confirmed it's, we're talking about seconds now. And I don't think this court is about arbitrary timing rules.
Or is it the flip side that in the tone of it, which in the context of someone who doesn't have their headlights on, and the guy says, oh, sorry, and flips his headlights on, and instead of saying, have a nice night, it's pretty obvious to these eyes, whether it's right or not, that the trooper had an opportunity and played it out as long as he could, legally and properly, and was in investigative mode from second 2. Disagree with that?
I think you look at the tape.
We all watch the same one.
I think if you look at the videotape, the video footage, it appears that the officer is asking lots of questions. Right. Yes, and as we know that she is entitled to do.
Well, let's change the facts. Could she walk up to the passenger side, he puts the window down, could she say, see the bag, and say, do you have anything good in the bag?
I don't think that. No, you've left. No, I think just asking to see the bag without any other facts, that he's not staring at the bag or looking at the bag. And I'm going to disagree with the court on that finding. But yes, no, I don't think she could just ask him to look at the bag. But I think
the bag were, let's say the facts are exactly these facts, except now the bag is in the back seat. Can she ask anything good in the bag?
And what difference would it make if it's in the back seat? I'm trying to.
Well, because Because all these cases where, and I'd say the SJC has made the law here, and we've followed them as we're supposed to do, but they've said you can't prolong the stop, that your conversation needs to be limited to the purpose for the stop, or if you get up to the side window and there's other things that you at that moment can observe, like the smell of marijuana, you can ask about whether the person had used marijuana. So if the bag is just in the back seat, she has the whole interaction, he's rifling around looking for his papers, the bag's in the back seat, she gets the information she needs to verify, and can she say, you got anything in that bag in the back seat?
Not without information that he's, and other facts that we have in this scenario, which is that he's far from home and he's looking at that bag.
He looked at the bag, okay.
So I think that there's two significant facts that the court needs to look at. I know the court, but I think the distance is a factor. I mean, it is a factor that, it was obvious that the trooper had questions, so.
So let's say he had gone to visit somebody in Providence as a social thing, and he's driving home, and it's the key Uber hours. I don't know what the key Uber hours are, but, and so he doesn't want to wait till he gets back to New Hampshire. He just wants to flip on his, I don't know how you do it, but like you go on Uber app, I assume, and you say you're a driver who's available in a particular geographic area. That's suspicious by itself?
No, it's the distance. It's the distance. But I mean, it happens. I know that this happens. Fun fact, I drove Uber for a while, so I know you can end up in far locations. That does happen. But it is a little something a little off.
All right.
It doesn't happen that often.
One more quick question. You and I know it, okay, but from the record, how do we know that you can check the New Hampshire regs for the insurance? Because obviously if you're in Massachusetts, by definition, you have auto insurance. If it's New Hampshire, happen to know it's not, but where is that in the record anywhere? And if it's not there, what do we do with it?
You can infer that there was an issue, that the fact that it was a New Hampshire license caused the officer to need to go back to her car, because she specifically mentioned the fact that it was a New Hampshire license, but she did not explicitly come out and say that New Hampshire has that rule.
Okay.
So I think it could be inferred. Can the court take notice? I don't know that.
That was my question. I don't know.
That's another question. You're keeping me here too long. I'm kidding. If there are no further questions, unless there are.
Thank you very much.
Thank you, Your Honors.
Well argued. The case is submitted. That takes us to 2024 P0724 Commonwealth versus Rodriguez. I believe we're hearing from Attorney O'Meara first.
To please the court, I'm Robert O'Meara, representing the appellant, Damian Rodriguez. Your Honors, in this case, the Commonwealth concedes that there was error due to the improper first complaint testimony in this case, but they disagree that that error caused a substantial risk of a miscarriage of justice. In this case,
So, counsel, could I just ask you a basic foundational question, because I was a little confused from the briefing. Was the error that the victim said, I told the babysitter and I told my mother about the September, I think it's 23rd event? That's one option. Mm-hmm. Or is the error that the babysitter and the mother each testified about as a first complaint witness about September 23rd? Or is it something else?
It was the former, Your Honor, that
that the victim...
On direct, the victim testified that she told Maria Pardo, and then she also told her mother.
Got it, okay.
So, well, the cases show that, the mere fact that she testified that she told somebody else without repeating the details, it still constituted error. And
you don't raise this, I think I'm saying something that's pretty obvious. You don't raise this as an ineffective assistance. In other words, that the attorney's strategy, apparent strategy of saying it's a credibility issue and actually asking the victim on cross-examination about that very thing, and then saying, well, in his closing, well, she supposedly told babysitter and mom, and then the police are called and no one even mentioned it to the police. that strategically was, you're not arguing that was a bad strategy, or you haven't argued that?
No, I'm not arguing. I'm not arguing it affects the counsel. In fact, when I read the transcript, my thought was that I don't know whether he would have objected anyways, but but no, I don't think it was ineffective. However, so the Commonwealth brings up that, well, as far as the substantial risk analysis goes, the Commonwealth comes up, well, it was a tactical decision, as you mentioned, Your Honor. So there was no substantial risk. However, when you look at the testimony, the other testimony, the cross-examination of the victim, he asked the victim, did Maria Pardo tell your mom what happened when she was on the phone? So the Commonwealth points to that and say, well, it's tactical, he needed that information. And then when he cross-examines the mother, he asks her, did and Maria Pardo informed you about the same thing?
Counsel, the case is partially impounded. I think you're using the babysitter name. I just want to be clear, you're not using the victim name.
Oh,
right?
no, Maria Pardo was the babysitter.
Let's just say the babysitter.
Okay. So I think that he was trying to establish through that questioning that the mother had knowledge of what happened from conversations with the babysitter, and he questioned why, at the end, he questions why she didn't tell the police.
So, counsel, wasn't it going to come out one way or the other that the mother was told because there was a conversation between the mother and the defendant after the event in question?
Well, yeah, I think that's correct, Your Honor, but I think that his sole purpose in the questioning of the victim and the mother was, again, to establish the fact that the mother knew from the babysitter and question, why didn't you tell the police?
Counsel, would you agree that the prosecutor's question, which was what happened when mom came home, was not designed to elicit a first complaint or a second first complaint, if you will? Do you agree with that, that it was?
Yeah, that's sort of part of the reason I said what I said initially, that the victim just sort of blurted it out, I think, and I think that it might have caught counsel off guard when she just blurted it out. And as far as
just on that point then, do you agree with the Commonwealth's assertion that the Commonwealth did not rely on the child's testimony that she told both the babysitter and the mother?
I don't know if I agree with that or not, Your Honor. I think that, again, it was, as far as defense counsel goes, it was just his effort to possibly, get to the point of, why the mother didn't tell the police about what happened. I think that was very important in this case.
Right, it suggests that the mother either didn't believe the child's report or that it never happened at all, right?
Yes, and if you look at some of her testimony, in this case, as you know, there were two incidents here. There was a September 23rd, 2019 incident, and then there was an incident, depending on what testimony, either a week before or 2 weeks before, the mother testified that the daughter said to her, I think I had a dream that somebody was touching me, and the mother didn't believe her. And then the next morning, on the way to school, she again questioned the daughter, and the daughter again said, I think it was a dream.
So that morning, the daughter said actually it happened.
Oh, yes, that's right. The daughter said it was the defendant. So I think, the mother thought that there was a credibility issue as far as the daughter's concerned. When the mother contacted the daughter's husband, I think the father testified that she testified that the husband said, well, she's she always lies or something to that effect. So, the credibility of what the daughter said, what the victim said, I think was an issue in the case.
But fair to say that the defense counsel used the fact that the mother was aware of the daughter's reports at the time, too, at least, at the time that the police were present in the apartment on the night of the second
Yes, Your
rape,
Honor.
to show that there was a credibility, or to suggest that the jury shouldn't credit the testimony that the victim provided about what happened, correct?
Yes, Your Honor. So, again, if I could get into the substantial risk analysis, I mean, it's the kind of case where, first of all, the rule, the court has to be sure that that the offending statement did not influence the jury. The kind of case this was, here you have an older man allegedly abusing a 7-year-old child, and I think I think the jury was, the sensitivity for a case like this, I think, was overwhelming. And I think anything that might have caused the jury to think about the testimony from the victim could have made a difference. And I think if you look at, because I thought about this for a while, I said, well, where's the prejudice? But if you look at the foundation for the doctrine was designed to refute claims that the victim was lying if she had not told somebody. So, in that regard, if that's the reasoning the court has for the doctrine, then so if she tells somebody, one person, well, okay, she's not lying. Well, if she tells 2 people, well, she's really not lying. So that's how I sort of looked at it, especially a case like this, which is so sensitive.
I take your point on that, but the first, as an initial matter, although it is true that it does not require that the victim's first complaint be detailed before it becomes error to allow the second complaint. I understand that. But in this case, it is a fact that the testimony about what the victim told her mother was essentially, I told her what happened. She
Yes.
told me what happened, and not a detailed recitation of the facts that would make a stronger argument for the inflammatory nature of that testimony. Is that correct?
Yes, Your Honor. I mean, of course, it would have been stronger if she had recounted what she told her mother.
Right, but she didn't.
But she didn't. But the mere fact that she told her mother, the analysis I just made, she told 2 people, so she really must be telling the truth.
I agree with you on that, and I agree with I understand the point you're making about what the purpose of the first complaint rule is. But do we not also, on our review, have to look at what the entire circumstances were, including the fact that there may be, in this particular case, benefit, as we've been talking about, to the defense to have this information in that changes the analysis that we would apply if there were no such advantage to the defendant about the admission of that evidence?
I agree with you, Your Honor.
Okay.
Yes.
So the Commonwealth argues that basically the defense counsel himself elicited testimony about the same complaint from multiple witnesses on cross-examination and highlighted in closing, suggesting the failure to object was strategic. What do you say to that?
Well, I mean, I think there were a couple of instances here when the cross-examination of the victim, counsel asked, did Maria tell your mom what happened when she was on the phone? So this wasn't a direct, so it was not, who did you tell besides the babysitter, but, did the first complaint witness tell your mother what happened? So I see a slight difference there. When he cross-examined the victim's mother, he questioned her, and she informed you about the same thing. Is that correct? And she answered yes. And I think when you look at that, he was again asking, did you have knowledge of what happened through your conversation with the babysitter. So, this information didn't come from the victim. It came from people that came from the mother and the first complaint witness. So I see a difference there.
But just so we're clear, through the defense attorney, not through the prosecutor?
Through the defense attorney, I'm sorry, Your Honor, in cross-examination, correct. And, if you take, if you take the analysis, substantial risk analysis a step further, the fact that he was, some of the cases about it, but in this case, he was, convicted of the 2 serious charges of rape. So I think because he was convicted, you can argue that, well, it might have made a difference. If he had been acquitted on one of the charges, I think, that question would have been answered in a different way. And I think if you look at the strength of the case here, it wasn't a strong case, so anything could have sort of tipped the balance in favor of the Commonwealth. There was no scientific evidence. He testified in his own defense. There were no witnesses, of course, and so it was essentially a duel of credibility. The jury looked at both of them and said, who's telling the truth? So, I think any slight deviation from the doctrine, I think, made a difference, would make a difference in a case like this. If you have no other questions, I'll rest up my brief. Thank you, Your Honors.
Thank you very much. We will hear from the Commonwealth, ADA Petalano.
Good morning, Your Honors. ADA Matthew Petalano on behalf of the Commonwealth. Before I begin, I just want to make one quick correction to the references in my brief. If I may just read a brief bit of the transcript. So this is on cross-examination at bottom page 15 of my memo and 125, 126 of the transcript. Okay, and so the babysitter had told you something that got you home quickly? Correct, yes. And after you got home, you spoke to your daughter, correct? Yes. And she informed you about the same thing. Is that accurate? And that was testimony elicited on cross-examination. So I do think the testimony on cross-examination was identical to that elicited by the victim. So getting back to my arguments, Your Honors.
But at that point, the victim had already made the statement, right?
Yes, Your Honor. So the victim's testimony had already come in. And I do say, had the witnesses testified in a different order, maybe this would have been admissible at that point. But the Commonwealth does concede that this was error, but this is about as technical an error as you can get, I think, on this record. And I say that primarily because this was a tactical decision. Defense counsel's strategy seems to have been to focus on the attack of the credibility of the mother and the babysitter. The primary way in which they did that was by suggesting that had this story been told to you, you would have spoken to police. That argument becomes much more convincing if the mother knows not only of the first incident, but also of the second. And so I think defense counsel made the strategic choice that whatever small bolstering of credibility this gave to the victim, it was worth it to be able to attack the mother's credibility.
So one thing I've always been puzzled about is, particularly here where you have a victim who was 7, the jury has to know that at some point the victim told the parents, because a 10-year-old's not coming to court without a parent, right?
Yes, Your Honor, and I believe there are cases subsequent to King where they basically say the first complaint doctrine can be sort of molded slightly if the court has a detailed discussion with counsel, decides about the benefits of it in this case. Unfortunately, that didn't happen here, and so I think we're left with the record that we have, in which case it would be error. But I do think that had they had that conversation, there would have been a world in which they said this simply gives a complete narrative of how the accusations came to light. And I believe Rivera is the case that talks about basically the purpose of first complaint doctrine is to allow for a complete picture of how the accusations first arose.
So in this case, the defense attorney waived opening, right?
I'm sorry, can you repeat the question?
He didn't open, did he?
I believe he had a small opening, but I could be mistaken.
Not much. But didn't lay out really the strategy at that point. So how from the record do we know that the strategy didn't develop, if not evolve, from the fact that the victim testified as she did, and then he's, okay, how am I going to make the best of this bad situation?
Sure, Your Honor. So Primarily, I believe that a thing that the court can look to is in the transcript, the defendant is objecting both before and after this testimony, showing that they're awake, they're alert, they're paying attention, and they're choosing not to object to this testimony.
Saying objecting to other things.
Other things on
Not
the
this.
page before and the page after on the transcript, and then there is no objection in this. What's more, I think that just the repeated nature of this throughout references that this is not some ad hoc strategy that came about, in the minute, but was instead their entire strategy. And frankly, I don't see anywhere else in the trial in which the mother's credibility is attacked in some other significant way. So without this, it seems like there would not have been a mechanism through which defense counsel could have attacked the credibility of the witness. I'd also just like to highlight for the court, King seeks to prevent a very particular type of harm. So when describing multiple complaint witnesses, they say they may unfairly enhance a complainant's credibility as well as prejudice the defendant by repeating for the jury the often horrific details of the crime. In this case, I think Justice Hand pointed out, the testimony was, I told her what had happened. That's not the horrific details of the crime. And I think, again, where this is simply giving a complete picture of how the accusations arose before police officers came, whatever minimal credibility enhancements that gives to the victim are very minor in comparison to the entire trial.
So you argue on page 19 of your brief that the defense strategy was to highlight the victim's mother's unwillingness to tell the police, who were actually at that point in her apartment, that her unwillingness would have opened the door and made the testimony admissible to establish the mother's state of mind when the police arrived. Could you just unpack that? I just wasn't following.
Sure, Your Honor. Unfortunately, it's a little confusing in my own brain, so I understand why it didn't come across in my brief. But essentially, my argument is that had the mother had testified first and then the victim testified later, that testimony may have come in to sort of refute that state of mind evidence that basically, well, if this were true, then you would have spoken to police. So I think that had the order of operations been different, then maybe that testimony would have come in. And I think that's just relevant for the substantial risk analysis. Additionally, Your Honors, this court should consider what the testimony would have been had this evidence not come in. There's several cases, I think Watt is the one that comes to mind, where the court examines if the jury's decision would have been any different had this evidence not come in. And I think in this case, as I highlighted, there are several times in cross-examination where they sort of elicit this information, they rely upon it in closing. It's very clear that the jury would have been made aware of this information even if this testimony had not come in. And lastly, this response was exceedingly brief. The Commonwealth didn't explicitly elicit it like Judge Brennan was talking about, and they did not rely upon it in their closing arguments. I think for all of those reasons, it is not a substantial risk of a miscarriage of justice. I don't cite it in my brief, but in Cabarrot, there's a very short paragraph talking about someone reporting to DSS, and I think that the analysis is relatively parallel here. So I just had that in preparation in case the court asked me for my strongest case, and I think that's pretty similar.
All right.
If there are no further questions, I'd rest on my brief.
All right, thank you.
Thank you very much, Your Honor.
I'd like to call the next case, but I'm unclear that we don't have the parties here, so I guess we'll take a recess.
Court is now in recess.
It's on the clock.
It's okay, exhale.
Yeah, exhale, life will
So
go
good.
on. These things happen but I'm still waiting for the clock to get to the right number. There we go. Okay, why don't we start over? This is 2024 P 1406 AM and others versus BG.
Good morning, and may it please the court, Ann O'Connor on behalf of Mr. G. I'd like to start, if I may, with the question the court raised in its September 11th order relative to the impact on this appeal of a subsequently issued extension order. And I would rely upon the case law that says that even if an extension order expires, the defendant maintains the right to seek relief. The appeal is not moot. The defendant must have an opportunity to establish in court that the order was wrongfully issued. And that would be CRS versus JMS, a decision of this court from 2017, volume 92, page 561, and the PIN is 565.
Do you have any cases where the order is not expired? Because the obvious reason why it's not moot in those situations is because there are all sorts of other issues that may arise, stigma being one of them. But in this case, the order is still current and in effect, if you will. And so regardless of what we do on this order, right, on the order as it's extended, if it was improperly extended, okay. And then that cures the issue if that's reversed. If it wasn't, then our doing something on this case doesn't impact it because the stigma, to the extent there is one, still continues, right?
I think I haven't seen cases on that. I did look. I think the stigma still attaches due to the sort of the repetition, right? You had an order that was extended 6 times versus you had an order that was extended 5 times or 4, whatever it ultimately could be. And it's, in addition to the stigma, it's how it would look if, there were a further restraining order
How does
application.
anyone ever know that? I guess that's my concern. How does anyone know that it was 6 times as opposed to 5 times? Or if we go back and if in fact it was 6 times, the first and the fourth, there was sufficient evidence, but the third, fifth, and sixth, if I'm doing it right. You get what I'm saying? I'm not
I do know what you're
understanding, I'm not
saying.
processing that one. I certainly understand it if it's expired or been vacated or
Right.
other situations like that.
Yeah, I think, and frankly, I don't know how they list it on a carry, if they show every single extension, and so then therefore there would be one less. I understand that the record of that particular extension would have to be destroyed if this is vacated, so that's another, it could be an issue in, again, God forbid, a bail hearing, so I would argue that he still has an interest in setting the record straight, at least as to this extension, and that the issue isn't moot.
Okay.
And I'm sorry, I don't have authority on that. Apart from that, I did want to withdraw an argument on page 21 of my main brief. I say that the court abuses discretion by not modifying the order as requested, and just seeing that the guidelines require the order to have been in writing, and it was not. I cannot say that was an abuse of discretion for the judge to have denied it. So with apologies, I do want to make that correction. In terms of the case itself, there wasn't much to it. The parties entered approached the bench, and the judge asked the 2 lawyers, are these children at risk, in fear of imminent serious physical harm? So the judge's charge, of course, was to hear evidence and decide on the basis of the evidence presented whether, in fact, that was the case. Instead, he asked the lawyers for their opinions.
But counsel, these sometimes a district court, a busy court might hear 40 or 50 of these, we do allow them to proceed informally. Did your client ever ask that evidence be taken at the hearing?
No, my client, his lawyer, listened to how the hearing went, understood that there was no evidence presented, that everything was...
Why isn't it waived? Why should the judge or the other party have known, oh, we need to actually swear witnesses and take testimony?
Because the judge has to take evidence. My client had no affirmative obligation until a case adverse to his interests was put in, and then he had an opportunity to rebut that. There was no case adverse to his interests put in, and I don't
So can I
imagine...
ask you just on that, because you said hear evidence, when it seems to me the judge's obligation is to receive evidence, and what information do we have on this record that the judge, which might include things that are on the record? I checked, the hearing took 10 minutes.
Mm-hmm.
It seems to me in 10 minutes, the judge could have read the file on that case probably a half a dozen times, while people are talking, granted, but isn't that sort of standard operating procedure? I mean, if you've done them, as they're talking, the judge is glancing up and down and then flipping through the papers and looking to see, and there's the first order, and if there was the affidavit. And we don't know because it's silent. But why should we presume that the judge didn't actually review the evidence of the ex parte affidavit, of the affidavit of the aunt, of...
Because if he were going to do that, he needed to make plain that he was doing that so that my client would have the opportunity then to call the affiant to testify or to object, to the admission of those documents. So if he did that, he had to advise my client that he was doing that so that there was an opportunity to refute.
Advise your client that he was reading and reviewing the file, which I presume, I don't know, I actually do know the setup of that courtroom, but they're probably standing maybe 3 feet away and can see what he's doing, so I'm not sure it would have been a great idea to make a record. I am currently reviewing this, I am now doing this. At the end, I find based on, would have been terrific, but is that the judge's obligation to do that if the parties are there, or is it the party's obligation to say, Judge, it doesn't look like you even looked at the file. You've been looking at us and listening to us, and you haven't, as far as I can see, even read a page of the file there, and what are you doing on this? What are you basing this on? How about some testimony?
I don't know what in your hypothetical the judge was looking at exactly.
Well, the ex parte affidavit, the initial order, the docket, the other extensions, the affidavit from the aunt, anything that's in the file that was likely handed to the judge.
But that's not how, respectfully, that's not how hearings work. Evidentiary hearings don't work that way, right? Unless...
If it's an evidentiary hearing. Respectfully, that is how restraining order hearings work.
Well,
We've done probably 10,000 or 15,000 of them, or thereabouts. That's how they work. And that's what I'm having trouble with, is whose obligation is it to make that record?
Can I step back and ask one question? Do you take the position that restraining order can't issue based on a hearing on representations of counsel?
I think if the parties agree that that's how, I think the parties could agree to proceed in a particular way. Here, it wasn't even, okay, I'll hear argument from you. It was discrete questions to the lawyers for the department and for the children. Are the children currently at risk of serious imminent harm? Were the children physically abused? And those were pretty much, how old are they? And again, I think that sort of refutes the idea that he was looking through the file and he was asking for very basic information. He didn't, yeah, I'm sorry. So I think it would have been fine if all the parties had agreed to do that. But I think that once he asked those questions, he got his answers, he listened to argument from counsel for the father, or from Mr. G. And then he said, okay, everything's extended. And for my client's lawyer to at that point have said, oh, well, I now want to call witnesses. And why would she? Because there was no evidence in front of the court. Therefore, the court could not find by a fair preponderance of the evidence.
The judge did find, and then your client or the attorney did not say, I object, you needed to have taken evidence. So why isn't that issue waived?
Because her remedy, or his remedy, is to appeal the order that was issued with a lack of proper evidence. I mean, the closest case I found was Bana versus Bana, which I do believe is in my brief but not cited for this particular proposition, but it was an extension hearing. The judge had the affidavit that had been supporting the original request for the initial restraining order. And the lawyer said, well, Your Honor, that the lawyer for the defendant, that affidavit doesn't show anything about current circumstances, basically. And the
Can
judge.
you spell the name of the case you just cited? Because I'm not seeing it.
B as in boy, ANNA
Okay.
versus Bana. It's volume 78, page 34. It's a 2010 case. And this court vacated the extension order there because there had been no information in front of the court as to the current circumstances, whether the person was at that time in fear of imminent serious harm. So that's sort of like this, I think. And I would also, under the...
Can I ask on that, is it your position that the affidavit from the aunt was not properly, whether the judge actually read it or not, which I take your point on that, but is it your position that that was not properly before the judge, the one that was filed in the motion a couple weeks before?
Absolutely. It was filed with a motion in limine. It was neither the motion nor the affidavit was mentioned at all at that hearing. No one appeared to be relying upon it. I would point out, if under the idea that this court can take judicial notice of docket entries in other cases, a recent single justice case with Justice Shin, 2025J0526, not a 209A, but a care and protection case where a judge was hearing a motion, did not take any evidence, took representations of counsel, afterward wrote a decision based on all these documents that had been filed in the case at other times, in the past. And I think even the transcript of a hearing that had happened months earlier. And there the department conceded, and Justice Shin found that the court could not then just go back into its file and look at a whole bunch of documents that no one had an opportunity to refute, or as she said, that could not rely on documents in the court's file that were not in evidence at the motion hearing. And then she also said, and the department agreed, that representations of counsel are not evidence.
I guess that's my question, is what to you does in evidence mean? Does it have to be marked as an exhibit, for example, or, for example, would the affidavit in support of the ex parte order, which is part of the record, would that be in evidence, technically?
It wasn't in evidence at that hearing, but I would say that if the judge said, I know there's an affidavit submitted in connection with the motion in limine, I'm going to consider that in this hearing, that the case law said would be fine for Zotto, because then my client would have the opportunity to call the affiant or in some other way dispute the affidavit.
So did the father violate the 209A order in place by arranging to have Dr. Montminy be at a visitation with the paternal grandmother?
I would say no. No one's ever said that that is a violation of the restraining order. Again, it's outside the record. I know there was a motion in limine, but it was not considered, it was not discussed, it was not raised, it was not argued. There's no indication the court looked at it or gave it any credence, but there's never been a judicial determination that allowing an expert in a juvenile court case, allowing an expert to observe visitation, which happens all the time in juvenile court cases, would be a violation of a restraining order.
I guess part of the issue may be whether or not there was notice, but the department cites the case Yana Y for the proposition that when a plaintiff has suffered physical abuse, a judge may reasonably conclude a 209A order is necessary because the damage resulting from that physical harm affects the victim even after, when further physical attack is not reasonably imminent. Do you think that case, do you disagree with how they're citing the case? Do you think it's not controlling here?
I think what I got from the case is that applies where the order was based on past physical abuse, and this order was not based on past physical abuse. It was based on fear of imminent serious harm. I would also note...
I guess I don't understand that, because my understanding was that one of the children reported that the father basically, if not tried to drown him, waterboarded him.
The father poured water over his head in the bathtub, was the factual allegation, and then someone described that as waterboarding. But he said, he couldn't breathe when the water was poured over his head. That was not in evidence, for one thing. That is from the restraining order hearing from the previous year, where it wasn't even in evidence there. Although one of the two, so there are two documents, an evaluation report and an affidavit of a clinician. The woman who wrote the evaluation report did testify in 2023, but she didn't testify as to any of that. And the affiant who wrote about that did not testify in 23 or in 24. And even if you want to say it was fair game for the judge to go back and look at that, which again, we have no indication that he did that, and I would not concede that that was fair game, but even if you wanted to say that, that helps you with, or helps the department with the boy, but not with the girl. There's no allegation ever anywhere.
At page 21 in your brief, you write that by extending the restraining order and suggesting that Mr. G seeks superseding probate and family court orders, the court abused its discretion. Can you explain that to me? Because I understand what you're saying, but it seems to me that your client's attorney asked the judge to address visitation, which the judge correctly pointed out he had no authority to do.
So,
and only the other courts would.
Is that the argument you're withdrawing?
Oh, was that the one? Did I miss that?
the piece about not making the modification order because the motion should have been in writing.
But that's not the argument then. No, but my point is that it's an abuse of discretion. I see that you're arguing that it was an abuse of discretion for the judge to say this belongs in probate and family court.
It wasn't that, Your Honor.
I know you say that, but.
My thought was, if, in the whole context, the judge took no evidence. He asked two lawyers to opine as to the ultimate issue in the case and apparently relied on that. And then he said, and this case doesn't belong here anyway, but it was almost like, I'm going to enter this order, but you go ahead and get it superseded. And that to me is what struck me as an abuse of discretion.
Gotcha, thank you.
If there are no other questions, I thank you and we'll rest.
Okay. We do have a time split on the appellee side, 10 minutes for the department and 5 minutes for the attorney for AM, AG, and GG.
Yes. Good morning. May it please the court. Julie Gallup on behalf of the Department of Children and Families. The department is asking for this court to affirm the orders of protection on behalf of children in its custody. Now, I'd like to address a question that Justice Brennan posed about cases, I think it was Justice Brennan, about a case where a restraining order has not expired, but a subsequent order has entered. I have Singh v. Capuano. It's 468 Mass 328. That's a 2014 case where at the very beginning of the opinion, the Chief Justice Ireland identifies that while the appeals have been pending, the underlying order is succeeded by other orders to which the plaintiff or the appellant did not object, so they dismissed the appeals. So I guess there's a question as to whether or not defendant objects to the extension of the most recent orders, but I would say that there is no relief that this, remand, I guess I would say like the
Wouldn't
relief
this
that,
be the classic case of capable of repetition yet evading review if this just keeps extending year after year? And I think we're on the 5th or 6th extension here. If, according to your theory, there'd never be an appeal.
yes, but I think that is a reason to reach the merits of an appeal, but with regard to this case, though, so should you decide to do that, the defendant is still not successful. His objection to how the hearing proceeded was not raised before the judge. At the outset of the hearing, the judge says to the parties,
Can I, before you go there, just to put a point on it so I understand it, your position is that if we review this order, and if we find that there was error, and if we somehow reverse it or remand it, I don't know what, the order that issued 2 weeks ago still remains in effect. It doesn't impact that order at all.
correct.
Right.
I mean, and there was just a hearing, and from the docket, the certified docket which I submitted, there was an entry that exhibits were filed a few weeks before the most recent extension hearing. So, the issue then of like what evidence or, what issue was before the court, I think that, defendant just had another chance, another opportunity to defend against extension of the orders. But the judge did let the parties know, he said, just give me a minute to look at the paperwork, please. Now, the counsel for the children filed a motion in limine. Now, it was titled a motion in limine, but I believe it was more to alert the court about a potential violation of the order. So attached to that motion was an affidavit from the maternal aunt, not only documenting the fact that the defendant had hired an expert to observe a visit, but also discussing the older child's continued fear and reactions to suggestions that he may encounter the defendant. So there was sufficient information for the court to consider that the children needed the orders to be extended.
Why isn't your opponent's point that, even if we assume that, this is not your opponent's point, but even if we assume that trial by, or a hearing by representation is appropriate, why is it not correct that the defendant at least was entitled to know what pieces of information the judge was relying on in reaching the decision outside of the representations of counsel, in reaching the decision that he did?
Well, the defendant was served with that motion in limine and the affidavit, so the defendant was aware that it was part of the court's file.
It wasn't referred to specifically in the hearing transcript, as I recall, but am I misremembering
No,
that?
it was not referenced, but I would argue that he could have called the maternal aunt as a witness to cross-examine her. Now, I would point to Idris Ivy, Hazel H., which discusses when representations of counsel can be sufficient. And my sister identified in her reply brief that case supported her argument that it was not, like, representations of counsel cannot be evidence. But I would suggest that the facts of that case are distinct from this matter. In that matter, the plaintiff had an opportunity to conduct a direct examination. The judge then halted defendant's cross-examination of the plaintiff and then just asked for closing arguments from the attorneys. So in that...
Excuse me for interrupting, but to
Sure.
Justice Hand's point, and I don't want to, maybe it was answered, but even to the extent that I assume that the parties could see the judge up and down and looking up and down and while they're talking, shouldn't the judge at least say, well, I've had an opportunity to review the affidavit in support of the ex parte order. I've reviewed the affidavit that was submitted 2 weeks ago as part of the motion in limine. I've looked at the prior docket entries on the extension, and here's where I am. As opposed to what happened here, which was, what do you represent? What do you represent? Here's my decision.
I think the better course of action would have been for the district court judge to explain the reason for the extension based on what information was considered.
is it your position that once the affidavit is docketed, made part of the file, that it is, for all intents and purposes, an exhibit for that hearing? Or does it need to be separately identified and marked and in some way acknowledged as an exhibit?
I wouldn't say that it's an exhibit, but I would say that it's paperwork that the judge considers as part of the hearing. And again, I think that where defendant's counsel, it seems like we don't have both of the attorneys saying, I'm agreeing to this procedure, but we do have performance of them agreeing to that procedure based on representations of counsel. Neither is saying, so I would say there was fairness, and that this case is distinct from the Idris matter where there was not fairness in the information considered because one party had an opportunity to put on a case and the other did not. In this situation, both parties and the children, everyone proceeded based on representations of counsel. So, I mean, for defendant to then expect for the judge to kind of identify an issue when no one has made it clear on the record that there is an issue here, this is how we're proceeding. As Justice Brennan mentioned, these are not necessarily long, drawn-out evidentiary hearings. The parties are just there asking for orders of protection.
So here we have a defendant who has completed various VA programs and has maintained his sobriety. Does the department have an obligation to analyze whether those efforts on the defendant's part bore any relation to his ability to parent or to lessen the older child's fear of him?
I think that that's completely separate proceeding in the juvenile court. That the orders of protection for the children were here. I mean,
I guess what I'm understanding,
sure.
I mean, he's, at least in this proceeding, the defendant is a bit, he's limited. If he can't see the children, so he has no way to lessen their fear of him. If he insists that they be called to testify, one could argue that he's putting his needs over their needs. And so how does he ever change the situation?
So, I mean, I could address that, but it would require me to discuss information that was before the court in the previous extension, which was part of the previous appeal.
Well, and do you contend that's part of the file and part of the record in this appeal?
I don't know if I can answer that with like a really good answer, but I'll say that he would have been aware in working with the department about who the child's various providers were. He could have then potentially called those providers to question them about the information that the children communicate to him, perhaps in therapy. Is this continuing to be an issue? It's something that's being discussed. So I don't think that he is necessarily precluded from putting on any sort of a case, because I do believe that he would have information based on his continuing work with the department about, who are these kids working with? How can I, challenge these representations that they continue to be in fear of me? So, I mean, I think that would require some strategy that's obviously not going to be part of the appellate record, but I mean, I don't think that the attorney was precluded from exploring those avenues. Thank you.
We'll hear from the attorney for the children.
Good morning, Your Honors. Scott Anderson on behalf of the children. May it please the court. I greatly apologize for being down the hall, expecting a break, and there was none. So very quickly to Judge Henry's question just now, there was appeal last year on the same case, and there was an extended conversation about the mechanisms of 209A orders. I don't know how to present that here, but it is there, and I'd be happy to put something in writing post-hearing if the judges think that's useful. Secondly, everybody from the SJC down agrees that Frazado is the guiding case here, and everyone from the SJC down agrees that fairness is the word we use when we look at the proceeding before us. I hate to put it so almost flippantly, but I word searched the appellant brief, and the word fairness does not come up. It comes up once in passing to italicize the word evidence as opposed to fairness. So I also am happy to hear, particularly from Judge Brennan, but I'm sure all of you have experience with these hearings. So I'd like to look at the docket more carefully, just call your attention to it, where if you glance through, you will find 2 contested hearings, one in 2023 and one in 2025, and then you'll find sandwiched in between a couple of entries for 2024, and that's why we're here. Okay, so the one from 2025 is 17 entries, which represent the hearing they just had 2 weeks ago.
Right, so that's not really before us, right?
No, but it's just an example of what a contested hearing looks like. I mean, what we're trying to do is consider the fairness of the proceeding and what does the district court judge have before them. And so what the judge has before them in 2025, as well as 2023, 27 entries for 2023, is a series of motions going back and forth, evidence being debated and offered and countered and opposed. But what we have sandwiched in between is one entry of a motion with an affidavit, and then the hearing. So the question is, was it fair for the judge to look at that affidavit?
Is it fair for the judge to look at the affidavit without specifying that's what he's looking at?
It's the only thing there. It's the only thing that was filed before the hearing. What else is he going to look at?
There's an entire file there, and your suggestion is, I take it, that counsel should have been counting cards in a way, keeping track of what had been admitted at different points. They're assumed to understand the judges regarding all of the past evidence plus whatever the new filing is, and that's what the basis of the decision is? Is that what the position
It
that you're
could be,
taking?
but I'm taking the appellant's lead and assuming it's just what was presented at this hearing. And so what was presented at this hearing was the affidavit attached to a motion. And so we walk into the hearing 50-50. Each party has a right to be heard. And on the plaintiff's part, there was this affidavit from a local caretaker available for cross-examination, filed 10 days before the hearing. And
Excuse me, and is it your position that just because it's on the docket that we should infer the judge actually looked at it?
I don't see the issue of it being improperly served before us.
No, but
Okay.
when the judge says, let me take a minute and look at the file, and
What's
this
he looking
doesn't
at?
follow it up with, and here's what I'm seeing, or counsel, I've reviewed A, B, C, and D. How do we know that the judge didn't literally look at the file, put it down and say, okay, looking for an extension, what's your position? What do you say about that? Have a nice day.
Well, okay, first of all, it would be clearly better if the judge had been, very particular in the findings and saying, this is what I'm looking at, and this is what I'm saying, and I'm giving you an opportunity to respond now, even though you've had for 10 days. He could have done that, and that we wouldn't be here if he did. But he did have the affidavit before him. If you look at Black's Law Dictionary, as the appellant mentions in the reply brief, an affidavit is a form of testimony, and testimony is a form of evidence. So to say it's not a 1%, a valid 1% of the 50-50, which is the standard preponderance of evidence, I'm having trouble seeing it.
So you acknowledge that the counsel for the child stated that children had experienced physical harm at the defendant's hand, but that the DCF attorney did not respond that way because the DCF attorney had not received a substantiated report. But at the time of this hearing, we're years out from the alleged physical assault, the pouring of water, or drowning, or whatever it was.
Yeah.
There was that ever being substantiated? I mean, aren't we sort of done, the department is done?
Yeah, well, this is where we get into some questionable territory, but looking back at the previous hearing, I mean, insofar as, okay, first of all, these are children. The judge is not going to put the children up on the stand. So you have the counsel empowered to speak on behalf of the children, whether they still have fear. That's one thing. But the second thing is we did have 27 entries of 9 months of various actions on the same case in 2023 for which it was appealed, and we were here last year. And so, as we're saying before, that's not off the docket. It's still there. He can take note of what happened up until here. It's a totality of circumstances, and whatever has been entered earlier, though it's not guiding, it's relevant and can add up to 1%.
All right, thank you. The matter is submitted.
Okay, thank you.
Our next case today is 2024 P1252. I do not know how to pronounce the party's name, so I'll say Nagy versus Nagy. Could be Nagy versus Nagy. Attorney Curran.
Good morning, still morning. May it please the court, Dana Curhan for West Naj. We were successful in our first appeal. We won the battle and lost the war. The judge essentially came up with very similar numbers, but for different reasons.
Was the judge permitted to do that?
If there was something in the record supporting that, yes, but we contend no. The judge actually found that the appreciation in the marital estate was 100% attributable to the market forces and not to the conduct of the parties. The judge then went on and said, but the judge actually made two mistakes. The first was that the judge found that the husband, during the period between the separation and the judgment, did not contribute to the marital estate. Now, the first problem with that is that the husband was disabled during most of that time period and was unable to contribute. What we have here is a disparate treatment of the husband and the wife. The wife was disabled for 10 years. The husband quit his career as a composer and musician, and essentially...
So the wife argues, though, that they weren't on parallel, that she had some significant illness that was basically a decade long, and that the husband was really experiencing some of the indignity of aging or just other temporary disabilities. So what do you say to that?
Well, I mean, temporary disabilities, but he had two detached retinas. He had a problem with his finger, which as a musician and a carpenter, that is problematic. And, you know, he asked the judge for temporary alimony, and the judge said no. He was unable to contribute financially to the marital estate during that time period.
Is your quarrel with the judge's decision here on remand chiefly with the substantive analysis, the math, or the credibility assessments, or none or all of the above?
Well, I mean, I don't think I really quarrel with the credibility assessment. There are a few of them I do, but, you know...
Not with her entitlement to make those assessments.
Well, she made an assessment that the husband, well, he had some things going on, but he didn't contribute to the marital estate. And I think where she was disabled for 10 years, he was disabled for 2 or 3 or 4 years during that time period in various degrees, and he couldn't work.
But the judge made findings about those two situations, findings that arguably differentiate the circumstances of the parties. For example, to Judge Henry's point that the wife had a longer standing, in some ways more comprehensive single type of disability. The husband had a series of shorter term disabilities, which the judge acknowledged. So why wasn't it an appropriate treatment of the evidence presented the way the judge found those facts?
Well, I mean, why is it different? She found that he was disabled. Now, he's disabled, therefore he cannot contribute. Why is that different from the time period, regardless of the reasons for the disability. I mean, it wasn't like he did something, like he went and took drugs and became disabled. He had some physical ailments that prevented him from working, same as the wife. Why are those disability periods treated differently?
That's what I'm misunderstanding, I think, and this is probably a fault of my comprehension, not your explanation. But why, in what way did the judge penalize the husband for his disability in a way that she did not comparably penalize the wife, if that's the way you want to term it?
Well, she didn't consider that period of disability. She didn't say, well, there was a 10-year period when he was the one supporting the family.
But those findings are in the judge's earlier findings, correct? That there was that period and the finding that the husband quit his work and they moved and made accommodations to adapt to the wife's disability, right? I
mean, that's right.
Okay.
But when you're considering how to divide the marital assets in a long-term marriage, I think the judge has to say, I'm going to consider the time period, that 10-year period, and give the husband some credit for that. Or, probably more appropriately, I'm not going to penalize the husband and give him a lesser share because he didn't contribute during the period of his disability. And that I think is the problem.
Did she have some sort of insurance for her disability and she was still contributing some fairly significant income from that?
I think that was a little bit later. I don't think that was during the entire 10-year period. I could be wrong about that. But, my understanding is even at the time of trial, she was collecting disability that was supplementing her income. And I think the second problem with the judge's findings, the judge said that the husband did not contribute to the expenses of the party's property, but did not consider that the wife, once she became, when she took over as property manager, kept all of the income. And there's some pretty significant income. I think in the office building there were 3 rental units. In the 25 Avery, I believe there were 2. And so she kept all the income. He didn't get any of it. And if you're, basic accounting 101, if you're going to charge one side of the ledger, you have to do the other side. So I don't know. And, I think in the original findings, paragraphs 77 and 78, the judge really added up the numbers right. Here's the income, here are the expenses, here is the depreciation, which she actually treated as something that's contributing to cash flow because, it wasn't an out-of-pocket expense. In the supplemental decision, the judge kind of mentioned in one sentence that income, but didn't actually address how relevant it was or that it had any relevance. The judge did not say, yes, he didn't contribute to the expenses, but didn't address the fact that he also didn't receive any of the income. I mean, he certainly could have used it while he was disabled.
Well, it seems like the implication from the prior order probably was that there should be some division based on if it was all market forces that caused the increase in the property. And so maybe the judge didn't follow that, but then the judge turns around though and says, well, he did get 31% of the increase in value based on the property she awarded to him, and that he, in fact, caused disruption and decreased the ability to earn income from the value, and so her award was fair. And what's wrong with that?
What's wrong with that is okay, so we don't necessarily agree with that finding, but I think we're stuck with it. But that addresses one particular property for a short period of time. If you want to go through and...
You mean the disruption addresses one particular property?
The disruption. Mm-hmm. And, if you want to go through and talk about, you know, who was the bad guy or whatever, you know, you look at, and I think we argued this in the first appeal, and I do argue it here. For example, the wife had them invest $500,000 with her friend who was running a Ponzi scheme, and so a lot of the profit from the California properties and a lot of their savings and a lot of the credit card, and they took out credit card debt to make this investment, and they just lost it all except $10,000.
Why was that in the scope of the remand?
Well, I think you have to look at everything. The judge is saying only the husband's behavior to the extent that it detracted from the marital estate can be considered. But I think if you're going to consider that, I think you have to consider it all.
But wasn't there was consideration, as I recall, and correct me if I'm wrong, in the judge's findings that the decision to invest, whether wise or unwise, was one that the husband agreed to. He may have had his reasons for wanting to keep his wife happy about agreeing to them, but that was a different in kind than a one-sided failure to, getting in fights with the neighbors, failure to clean up your belongings outside one of the rental properties. Those were two different types of things, arguably.
They may have been, and you know that's not really my main argument. I think my main argument, you know, is basically disparate treatment of the disability, and you know there's an awful lot of income generated by these properties, and that was just never considered. I mean, it was mentioned in the first decision, and it was not mentioned in the second decision. So if you're going to say he didn't contribute any of his income to, or any of his sweat equity to to maintaining any of the properties, then I think you also have to say, well, once she became property manager, she kept all the money.
Is your argument that there wasn't updated information in the findings after remand about the additional monies that were obtained from the rents, or that overall it wasn't included?
Oh, I don't think so. I mean, I think in the first decision, in paragraphs 77 and 78, the judge did go through 2017 to 2021.
Right.
You know, obviously from 2021 to, you know, 2025, where she got the three most valuable properties and he got the one property, I think the disparity is probably greater now, but we can't consider that. So as of 2021, she did consider all of the, you know, she had findings of the income, the expenses and the depreciation, which I think she got right, but then sort of used that in the second decision and ignored the income part of it.
But was there a new evidence about, this is where I think I'm missing the piece, was there new evidence about updated information about the rentals?
I don't think there was updated information. I think that it was correct, but you know, and it was argued in the court below that you know, you have to consider the income.
I guess what information was the judge supposed to rely on then to fill in the gaps after 2021, given that the original decision was in 2022?
After 2021, it's not really relevant because this court you know, told the judge you have to consider it as of 2021.
Okay.
But the judge actually had those findings as to income, expenses, and depreciation. And I think all the judge had to do was say, okay, let's consider those three factors, and it's not in the amended decision. It's not, it's just not there. The income part is just not there.
Okay, thanks.
Unless there are any further questions, I will rest on the brief on the remaining points.
Thank you.
Thank you.
Good morning, Your Honors. May it please the Court. I'm Peter Cooperson. I'm co-counsel for the defendant, the appellee, Meta Elizabeth Nag. I think that's how they pronounce it, Nag. In any event, so we're requesting that the judgment on remand be affirmed. the trial judge did not abuse of discretion in apportioning the market-based increase in the 4 properties, nor did she abuse her discretion in equitably dividing the marital estate after considering all the required findings under Mass General Law, Chapter 208-34. The judge followed directive of this court on remand. She determined the increase in value, the fair market value of the properties from 2017 through 2022, that 5-year period, was solely attributed to market forces. She then determined what, if any degree, that portion of the increase in the market value should be shared by husband. And she determined that husband should share in awarding him one of the 4 properties, which was 31% of the total market-based appreciation, and resulting in an equitable division of the marital estate, 55% to wife.
Do you have a response to Attorney Curhan's argument that the judge improperly gave disparate treatment to the respective disabilities?
Sure. So the court specifically found wife was disabled, and it was from 2000 to 2010. There was no finding that husband was disabled. And during that period, that 10-year period that she was disabled, she received Medicare disability of about $200,000, and then she received non-taxable disability from her Northwestern Mutual policy of $1.15 million during that 10-year period.
Okay.
With respect to the husband, again, the judge did not find that he was disabled. She said there were periods of time during this 5-year period that there were times when he was unable to perform his work duties. But of those 5 years, 2 of those years, he acknowledged from 2017 to 2019, he was able to perform all his work duties. And these were very limited periods. And I would also suggest that his income between 2010 to 2021, 2017 to 2021, just on employment, not on IRA distributions or things like that, averaged about $50,000. He lived rent-free for most of the time. He performed renovations to his girlfriend's house, including putting in a new driveway, and he was paid $10,000. And with respect to the rental income, there were not significant rental income. 1 year, 2017, there was a loss, and this is not including depreciation. 2018 was about $34,000, and 2019 was $38,000. I don't believe the judge made any findings on 2021 or 2022. What happened was the experts, both experts, only testified as to, in their analysis, was from 2017 to 2019. But regardless of that, on a tax return, right, for deductibility purposes on rental income, the mortgage is only the mortgage interest. It does not include the principal in the mortgage payments. So she was paying more than what the rental income showed on, as the judge found. And in addition to that, she made repairs out of her own pocket to 50 Old Lighthouse Road that actually was awarded to husband. She paid for the exterior of the house to be repainted. She spent about 15% of the deck boards to be replaced, window casings. She spent about $50,000, $60,000 repairing or rebuilding the shed that the husband had previously built, and she had to repair it or rebuild it because there were leaks in it that husband acknowledged. She paid $25,000 in legal fees to evict one of the tenants at one point. Husband didn't help in any of that way. She spent another $3,000 evicting another tenant. So it wasn't just there wasn't sufficient rental income to maintain all these properties. She also managed.
Basically, the husband, he's got a lot of specifics, obviously, and his case is well argued, but he's basically saying, the clear implication of the remand by the prior panel was that the market gain should be more evenly divided and that didn't happen. So what do you say to that?
I do not believe that's what this court had said on the initial appeal, and that's why it says, what, if any degree, husband should share in that appreciation. And so, again, the resulting equitable division was 55% wife, 45% of the husband, and that out of a $2 million estate, I think that came to about $90,000. That's not an abuse of discretion. Unless you have any further questions, I'll rest.
All right, the case is submitted.
Thank you.
That takes us to 2024 P 1325, Department of Children and Families and another versus Mother. This case is impounded. I will say, when I see the parties use the child's first name in the brief, that almost invariably results in the child's name being used in the argument. So let's not do that. Let's just refer to the child as the child.
Good afternoon, and may it please the court. I'm Sherry Krasner here on behalf of the mother. My client lives in Western Massachusetts, and she's watching the argument on the live stream. I set out Justice Lowy's important observation from footnote 15 in adoption of Luke in my brief, but I'm going to read it again now. It should have resonated with the trial judge, but it did not, and it sets up a good framework for this court to find reversible error. Justice Lowy said that it would defy logic for a judge not to consider a parent's past history. However, that is not to say that the past is prologue, or even that history often rhymes. Ultimately, the issue is how fit this parent is to raise this child. There is always the possibility of redemption, and each adjudication must be resolved on its own merits. In this case, the deck was stacked against my client even before the child was even born. You can see at Record Appendix, page 131, that there were plans in place to remove this child even before the mother gave birth. She then gives birth. Child is healthy. There's no drugs in mother's system or in the baby system. Mother's bonding appropriately with the child in the hospital. Mother has obtained 7 months prior a restraining order against the father of the baby. She's doing everything right. And yet, with no evidence, the department comes in. They come in the next day only because the child was born on a legal holiday, and they come into court and they remove get an order to have the child removed in an ex parte proceeding.
Attorney Krasner, putting aside for the moment whether the evidence supported it, do you stand by the argument that the judge did not conclude that DCF met their burden with respect to unfitness? Because it just seems to me that, and I'm looking, I mean, it's peppered throughout, but conclusion of law 4 and 15 explicitly says it.
Well, the judge sets out the correct legal standard, but I think what she says in conclusion 4 is really what's telling when she talks about it's in the best interest of this child to remain with the prospective adoptive resource. I think yes, she uses the right language in some of the conclusions, but I think she's really telling you where she's coming from. And of course, this is a child, again, the removal was orchestrated before the child's even born. She's placed with a caretaker who has a good history in taking care of children. She's bonded with this child. Of course, looking at it only from that framework, it would be contrary to the child's best interest for removal, but that's not the standard.
Why don't the judge's findings show that she applied the correct I understand your point of view that it loomed large in the judge's mind from your client's perspective that the child was in a good situation since her removal. But why don't the judge's findings otherwise support by clear and convincing evidence the mother's ongoing unfitness?
Well, let's look at the factors in this case. Substance misuse. My client had been clean since November of 2019. Trial in this case was in beginning of 2024. No evidence of any substance misuse. And the social worker even says that we never considered that mother was abusing substances.
Well, let's be clear, though. Mother did attempt suicide using a substance, right, in that period?
That was before the child was born.
Right.
So it was after her sobriety date, which she said is 2019.
And to be clear, I think that, we should acknowledge the mother's efforts at sobriety and that, it's great that mother has been able to do that. And I want to encourage that.
Right. And she was continuing to go to AA and NA meetings. She had a relapse plan in place. She was doing all the right things. So that's the first thing I would look at.
To be fair to the judge, she did acknowledge that in her findings, right?
She did acknowledge it, but she's also saying that this mother is
And she
unfit
said,
and
well,
talks about...
Right, she talks about not really, the mother not being able to appreciate the significance and the fact that she was still exposing herself to people with substance use issues.
Well,
I mean, however that was weighed.
That's how she used it, but it was one incident that someone was in her home who had a history of substance misuse. But no evidence that during that time that those two people were living in the home that they were misusing substances or causing mother to misuse substances. Another factor we look at in these cases is the mother's mental health. He acknowledged that mother carried diagnoses, but at the time, even when this case first came in, if you look at the investigator's report, so that's a few months after the case came in, the mental health provider told the court investigator that mother's medication compliant and she's doing what she needs to do. And she had no mental health hospitalizations during the pendency of the proceedings. She was taking her medications. She was meeting with she had a DMH counselor in addition to her providers. So again, here's another factor that...
As the judge found, the mother testified and the judge found that the mother was continuing to have twice a month, was I think the figure, poorly controlled, if controlled at all, anger outbursts in her history, in fair consideration, had included some very dramatic episodes of violence associated with those kinds of, not towards the children, but towards other people associated with her anger, correct?
Well, I think that's, though, the important fact that you laid out there, not in front of no evidence that she ever displayed anger in front of any of her older children, and also in her visitation with the subject child, never, and she was having those regular visits, and never displayed that anger. And there was evidence that anger management was part of the treatment that she was doing with her mental health providers. So that's another area frequently that the court will look to assess whether a parent is currently unfit. And let's look at domestic violence. Mother was meeting with a counselor at the Elizabeth Stone Center and was discussing issues of healthy relationships. And the counselor said that mother was developing that awareness and that the counselor, had no concerns about mother engaging in or being in a dangerous relationship. And the father of the child, who was the abusive partner, was deceased. He died 5 months prior.
But is the judge's finding that the mother failed to, despite maybe 10 years of involvement at the Freeman Center, the mother had failed to develop an appreciation for red flags of domestic violence? Is that a clearly erroneous finding, the judge?
I am saying that, yes. And the mother also acknowledged in her testimony that in those early years, when she was still abusing substances, that sort of was a barrier to her inability to recognize just what a serious problem domestic violence was. And I also, while acknowledging the very horrific act with the father of the baby that I believe you were alluding to, there's nothing on the record to show that there was a criminal prosecution for that. I mean, she was arrested, she was held for several hours, and there is nothing else in the record to say what happened after that horrific incident, other than that mother obtained a restraining order against the father. So I think we shouldn't be ascribing too much weight to that incident because we don't really know what the outcome of that
The mother was denying that it happened, or that it...
She wasn't, there were no criminal charges brought against her for it. So again, I'm not trying to say it didn't happen as it's laid out in the record, but I think the fact that there never was, or there's no evidence that there ever was a criminal prosecution, that does suggest something. Also, the visits, here's something else we look at when we think about, is a parent currently fit? And this mother, absolutely at the beginning, was consistent with her visits at the DCF office with the child, and all of her interactions with the child were appropriate. There is, in the beginning of 2023, when she started to have some medical procedures, she wasn't as consistent with some of the visits because it conflicted with either an appointment or her healing, but she did continue to come to the DCF office. There is the suggestion that she could have gone and should have been going for the additional off-week visits to the prospective adoptive resource, but the record is really poorly developed as to that. There is nothing in any of Mother's action plans that indicate that she was permitted to have those visits on those off weeks.
So can I ask assuming we accept your representations, and it's hard because how big should the snapshot be? Is it narrow right around the time of the hearing? And
could I say?
Sure, my microphone's off, yep. How big ought the snapshot be? Is it just the time of the hearing? How expanded is it? And even if individually each of us would weigh the factors, the evidence differently, or collectively we all weigh them the same, but it's different from the judge, it doesn't really get you to where you need to be, right? Because ultimately the judge identified evidence, weighed evidence, and how do we arrive that she abused her discretion in the way that she did it?
Right. I understand that it's not this panel's job to do fact-finding. I get that. I argue it all the time when I'm on this side. But I'm not sure what she really looked at, other than this is a woman who gave up her rights to 4 children before. As I said, the substance misuse, it's not an issue. The mental health, she was in treatment doing what she was supposed to do. The domestic violence, her counselor was saying that she had no concerns and Mother was making progress. The visits, she was doing the visits. Service plan compliance, she took a parenting class. She otherwise complied in terms of being in treatment. And another thing the judge puts a lot of emphasis on is, she said, well, Mother didn't really have a plan for having the child. And I think here, too, the evidence doesn't support that. Mother knew she was in an apartment that contained lead paint, and she knew that she couldn't have a child living in that environment. She put herself on a list to get into another apartment, and she could only go for a 1-bedroom because she didn't have the child with her yet, but it was a situation where if she then got the child, she could get to a 2nd bedroom. I would say that is a plan, so I'm not really certain what the judge is talking about in indicating that Mother did not have a plan. The mother acknowledged that the child had a bonded, clear relationship with the the great aunt. Mother never said, oh, I won't allow her to see the great aunt. I mean, mother said, of course, I'm going to rely on the great aunt. And another thing the judge seems to do is she seems to rely on the fact that mother had to rely on services to assist her with money management and other sort of aspects of keeping her life in order. Adoption of Chad tells us that that's not a reason. If a parent needs those outside supports, that's not a reason to say that the mother is currently unfit. And the mother here recognized that she needed those outside supports. So I'm just not certain what the judge relied on, this sort of general idea that, okay, this mother gave up 4 other children, this mother carries some mental health diagnoses, this mother has had a difficult past. But to do what you do in these cases, to permanently sever the relationship between a parent and a child, permanently sever it, I don't think that the evidence here rises to that level of clear and convincing. I see that I have less than a minute. Unless the panel has any questions, I'll rest on my brief. Thank you very much.
Thank you. We have a time split on the appellee side. We have 7.5 minutes for the department and 7.5 minutes for the child.
Good afternoon, Your Honors. Judge Henry, we're going to split our time 7.5 minutes each. If you could let me know when I have a minute left, if I'm still making my argument, I'd appreciate that. William Cuddle for the Department of Children and Families. We're asking the court to affirm the trial court's decision finding mother unfit, terminating her rights, and allowing the child to be adopted by the great aunt in this family. The findings speak for themselves. I think a careful review of the findings shows that the court used the proper standard of determining that the department met its burden of showing that there was clear and convincing evidence of mother's unfitness in this case. If you look at the summary, at the end, the last paragraph of the summary in the court's findings, she uses that language and explains what the current unfitness was. In conclusion 4, that my sister points to, that conclusion sets out 6 different sentences. I understand the first sentence, the next 3 talk about different levels of mother's unfitness. And the 5th sentence basically says, it says that there's clear and convincing evidence of unfitness here. This case,
So Attorney Krasner makes the overall argument that the mother was doing everything right as to this child, had sobriety, was not I don't think was in the relationship anymore, was seeking domestic violence counseling, was doing the visitations. Why is she wrong about that?
She's wrong about that because the mother wasn't, first of all, the mother wasn't doing everything right. I want to say before I continue, though, as you know, the court in this case acknowledged mother's efforts. Clearly in several places that mother had addressed her own substance abuse issue from 2019. Court wasn't concerned about her particular substance abuse issues. She participated in some services, a parenting class. She had been involved in domestic violence counseling for a decade. She had participated in some services. She did not participate in a psychological evaluation or a parenting evaluation. And the real issue in this case, and what the court found, sadly for the mother, was that despite some of her efforts, there was evidence that she hadn't developed the insight about how her past was affecting her current circumstances, and she didn't develop the parental capacity to take care of this child. If you look at the time period between the summer of 2023 and the time of the trial, mother had let one individual, acquaintance of hers, come to her home in November of 2023. She had to call 911 because I think the term is huffing aerosol cans. After January, mother let 2 acquaintances live in her home. Actually, one lived in her home, one visited her home, who had known substance abuse issues. Mother testified and the court found mother stopped going to her NA meetings for a period of time because she didn't trust these people being in her home. She let people into her home that were exposing herself to substance abuse issues, and if the child had been at home, the court said that she would be exposing the child to dangerous circumstances. Mother never addressed her, never showed that she had an understanding of domestic violence history. She testified, the court found she didn't understand the warnings. She had, as you know, that she had taken out a restraining order to her benefit against the father who was awful to her. But she kept in touch with him. She modified the order to stay in contact with the father until his death, knowing that he was still using substances. So she did make efforts, but they weren't clearly enough. The court had every right to consider Mother's past circumstances, but the court certainly didn't rely on her past circumstances. The court relied on that information, Mother's current circumstances, and taking all that information together, that's how she determined that Mother's unfitness was not temporary. If you have no further questions, I'll rely on the department's brief. Thank you.
All right, thank you very much. We'll hear from counsel for the child.
Good afternoon. Attorney Susan Taylor for the appellee child. May it please the court. The trial judge did not abuse her discretion in determining that this mother was currently unfit and that that unfitness was likely to continue into the indeterminate future. My sister seems to suggest to the court that that finding is based solely on the fact that she had 4 other children who were placed in care and that she no longer had parental rights for. But that really was just the beginning of the things that made Mother unfit. And I would suggest that certainly prior unfitness can very well be a prognosticator for future unfitness. And that is exactly the case here. Mother has, and I would suggest to the court that I think the decision that the court issued was very balanced. I think she gave Mother credit for the things that she had done, the things she had done right. But I think the court also recognized that Mother suffers from major mental illnesses. She's been diagnosed as bipolar, schizophrenic, depressive. She suffers from anxiety, PTSD, for which she takes all different kinds of medications. And Mother's own testimony is that she still suffers from anger issues. She says sometimes just once a month. But when she suffers from those episodes, she feels like yelling, screaming, and punching something. Although Mother claims that she has been sober and drug-free since 2019, the court correctly noted that she overdosed. She tried to commit suicide with drugs, and the court noted that she had also taken Percocet following a procedure, something that somebody who claims to be clean and sober would not do. In addition to that, she continues to engage in relationships with substance users. So in this case, father had a substance problem. Mother allowed a woman and her boyfriend to be in the apartment and was afraid to leave them alone to come to one of the children's visits because she was afraid to leave them alone in the house. And one of those people who were in her apartment killed her cat, and she didn't take the cat to the vet. She said because she didn't have the money to do it, but the court didn't credit that testimony. But the question is that, and I think there was also the testimony of the great aunt where my client currently resides, that on one of the occasions when she went to that apartment, there was an ambulance there, and Mother told her that someone had been in her apartment and had overdosed. This Mother has been in numerous relationships that involve domestic violence with both of the partners, the father of the oldest child, who also lives with the great aunt, and also with the father. It was alleged that she tried to set the father on fire with an aerosol, and that she committed an assault and battery on the father's mother. And while we can speculate about why there weren't criminal charges, I mean, the fact is that if she suffers from a mental illness, it's very likely that there were no criminal charges. As to the visits were not consistent. As a matter of fact, the aunt had really kind of given mother free rein to come and see the child whenever she wanted to, and mother just never simply availed herself to that. Mother was given an action plan, and the tasks that were on that action plan were reasonable. But she never completed a parental fitness exam. She never did a neuropsych exam. And I think that if you take all of those things together, you just can't come to the conclusion that the department didn't prove by clear and convincing evidence that this mother was unfit and that unfitness was likely to continue. And the court certainly did not abuse her discretion in approving the plan of adoption. My client will be 4 years old in November. She has lived with this great aunt and her 2 brothers all of her life. There was testimony, she's very bonded to this family. So it certainly was not an abuse of discretion to approve the adoption plan. So on my client's behalf, I'd ask you to affirm the court's ruling and affirm the plan of adoption.
All right, thank you very much. The case is submitted. That concludes today's session. I want to thank our court staff for making everything run, and we are adjourned.
Court all rise, please. Court is now